In this courtroom, truth doesn't whisper, it explodes. One claim, one witness, and one decision could flip everything upside down.
Morning, Your Honor.
Morning.
Assistant Public Defender Sandra White on behalf of Danina Combs, who's appearing by video.
She can't appear via Zoom. She needs to get here. It's a violation.
She's the one who's broke her back in a car accident. I believe there's paperwork in the file from a couple weeks ago.
She's unable to get here?
No, she's still bedridden.
Do I have updated medical indicating that?
I don't know if it's updated, but from what I saw, it was presented to the court about a couple weeks ago.
I have just treatment from 9:13 to 9:15. I don't have anything after that.
All right, I can try to get something within the next few days.
Defense counsel is correct. The last time we were here, there was medical documentation provided related to an injury. But I do also have the same community corrections report. It sounds like the court has indicated there have been no tests.
And that's due to the car accident.
And I have no updated medical.
I'll get some updated
because it
correct.
doesn't indicate that she's been seen after that time frame that I indicated. Our probable cause conference will be adjourned October 23rd, 2025. I'll expect updated medical or the defendant's appearance here at. So as of right now, that's in person.
I'll do that.
That's until such time we receive the proper medical documentation.
Thank you.
Thank you. Court does call the case. People versus Lermaine Palmer.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Palmer, who's approaching now. Mr. Palmer, will you state your name for the record?
Lermaine Palmer. Thank you.
Your Honor, Mr. Palmer is asking that the court set his matter for preliminary examination. I will inform the court that we do not have the video discovery. I discussed this with Mr. Palmer at great lengths. The video would show what the complainant made to the police officer's statements on a report of a domestic violence. I informed him that it would place defense counsel at a disadvantage, but he is asking the court to still proceed with setting the matter for preliminary examination at this time.
Is that correct, sir? Correct. You understand that you will not be entitled to an adjournment if that video doesn't show up? Correct. And that your counsel is indicating to you that that places your case at a severe disadvantage? Correct. And you're just going ahead despite the advice of counsel? Correct. Okay. We'll do that with his law degree. Preliminary examination in person, October 21st, 2025. That's before at 9 a.m. before me. As to the bond.
It's come to my attention that Mr. Palmer has contacted the victim 43 times since arraignment to her listed number in the police court from his own PIN. In these calls, he's providing her details on how to get the case dismissed, not to press charges. He tells her to contact our office and tell us that she's not wanting to press charges. He says things like, it's all up to you, and I'm trying to get the F up out of here. He also tells her that she should be calling our office again. He tells her to twist the story so he can get out, and I quote, the hell out of here. You gotta keep calling these people. I'm not trying to stay here. I do need you to do work on your end to get me up out of here. So at this point, I would be asking that phone privilege to your vote, and I do expect that exam. There could be a potential forfeiture by wrong of motion for Mr. Palmer.
Your Honor, I will say that Ms. Zenda did inform me of that motion that she was going to be making earlier today. I have not had a chance to review the calls. I asked that those be sent to our office so we could be in preparation for the preliminary exam on the 21st.
All right, we'll have those, and I will indicate that defendant's phone privileges are hereby ordered revoked. His bond will continue at this point in time. I will also, upon the filing of the motion, if she does not show, then they may proceed by forfeiture. The defendant made his bed, he'll have to lie in it. Thank you. Bond continued. Just call the case. People versus Drew Connor.
Notice that pause? The judge isn't buying it. You can almost feel the courtroom hold its breath, waiting to see who breaks first.
Connor.
Six Drew Connors. We're ready in this matter. We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, on behalf of Mr. Connors. Mr. Connors, please state your name for the record.
Drew Connors. Thank you.
Connor, My client wishes to waive to preliminary examination and agree to be bound over to circuit court.
Is that correct, sir?
Yes.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts. Mr.
Thank you, Your Honor. We acknowledge receipt of the information. We waive its reading on the record. My client will stand mute at this time.
Defendant having waived formal reading, standing mute to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
December 1st at 1:30 with Judge Hammoud.
December 1st, 2025, 1:30, Judge Hammoud.
Thank you very much, Your Honor.
Bond will continue. Thank you.
Thank you.
I'd like to address the bond.
Everything place.
Your Honor, so my client has a planned trip to Chicago to see his brother. He'd like to be allowed to be able to do that,
To do what?
to go to Chicago this weekend and see his
For
brother,
what?
to hang out with his brother.
Yeah, to visit my brother.
Brotherly love, yeah. Not
That's
Philadelphia,
Philly.
not Philly, Chicago. Big shoulders,
I get it mixed up.
big shoulders, city of big shoulders.
That's not what it's called. Chicago. So aren't the Cubbies out?
So
No, they're still in?
Live.
Well, you can go if the Cubs win.
I will.
If they don't, you can't, no. When does he want to go?
This weekend, yeah.
For what days specifically?
What is it?
I believe it is.
How old are you? How old are you? You have no idea when you're leaving.
The 10th
or
through the
coming.
13th, yeah.
I didn't.
10th through the 13th?
10th.
I didn't get that far. I'm sorry.
You don't want to plan without permission.
Yeah, see, thank you.
Defendant may travel to Chicago. You
And
know, that's pretty much just one highway. Just stay on it. All right. Stand through the 13th.
There's one more thing, Your Honor. We had to test the waters in that person. So the address where this event occurs, he has a lot of property there. He'd like to be able to retrieve that property. It doesn't have any.
Because there's a no-go to?
Yeah,
He can go, but if he arranges a civil standby, I'm not going to have a problem.
Okay.
Civil standby was ordered at the arraignment.
So furthermore, it's not anything, there's no victims there that he would be encountering or anything like that. It was a noise complaint to a place where he was welcome to be. So just so the court had.
Okay. All right. Very good. I've signed the order that he can travel to Chicago.
All right. So it's fine.
Thank you.
It's the 20.
Court does. Oh, you got to keep moving.
Tonight.
Go west. 94. Keep going. Soon. We're done. All right. Take care. Court does call the case. People versus Barack Howell. Who is it? Oh.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Howell. Apologies, Your Honor. State your name for the record, please.
Eric Howell. Barrett.
Your Honor, we are requesting an adjournment for plea negotiations. I do have a green sheet. We are referring Mr. Howell to mental health court.
Got it.
So I'm going to ask you to sign this.
Do we know how much time their evaluations are taking at this point?
I do not, Your Honor.
I don't either. I
I think with the other one, I'll just adjourn it to November 6th. We'll see where we're at from 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court does call the case People versus Shawante McFarland.
Actually, want to call this for people.
Good morning, Rob J. Hill on behalf of Mr. McFarland. Jante, would you state your name for the record?
He's muted.
Judge, while he's being unmuted, may we approach very briefly? Very briefly.
Yes.
Thank you for the bench conference and the prosecutor's input. Based on that, I would ask if we could have a significant adjournment in this matter for my client to receive services.
All right, Mr. McFarland, can you state your name, please?
Yes, sir. Dejon Day McFarland.
Thank you. I'm going to adjourn your probable cause conference to November 6, 2025, 9 a.m. Bond will continue. Okay?
Thank you,
Thank
sir.
you.
Thank you.
Thank you.
Come and see you.
All right.
Court does call the case, People versus Jaden Patrick.
Oh.
Jennifer Overwater, Assistant Prosecuting Attorney, on behalf of the
And Assistant Public Defender, Chances Fair, I can release on behalf of Mr. Jaden Patrick, who's approaching. Mr. Patrick, can you use the bench to begin for the record, please?
Jaden Patrick. Thank you.
Your Honor, we're asking that this matter be set for preliminary examination, please.
Discovery is complete.
To our knowledge, Your Honor, yes.
People have their witnesses available the 21st.
She'll certainly try.
Preliminary examination, October 21st, 2025, 9 a.m. Bond continued. Please Judge Moore. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Rachel Kosier.
Michael Gaddy, Assistant Public Defender, on behalf of the defendant, Your Honor.
Your name, ma'am?
Rachel Ann Corser.
All right. I have before me a plea form that indicates defendant will be pleading guilty to an added count 2 of operating while intoxicated, second offense to 1 year. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's right, Your Honor. That is correct, Judge.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so
Yes.
state your name.
Rachel Ann Corser.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense. That's a misdemeanor, punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. Could order your vehicle immobilized. It could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
Nope.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of May 21st, 2025, at the location of I-94 near Baker Road, Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Do you recall what you had and how much?
Do I recall?
Sure.
Oh, don't recall how much I had.
Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
I was speeding.
All right. You're not challenging the right of the police to stop you in this instance, are you?
No.
All right. Were you ultimately arrested?
Yes.
All right. Were you taken to the hospital?
Yes.
And was there a blood draw?
Yes.
And what were the results of the blood draw?
It was 0.10, Judge.
0.10?
Yes.
Do you have any reason to dispute those blood test results, ma'am?
No.
All right. And have you previously been convicted of operating with the presence of a controlled substance on or about October?
And here it comes, the moment that could decide everything. Watch closely. One sentence could end it all.
19, 2015 in the 14A2 District Court and or of operating while intoxicated on or about October 29, 2024 in the 12th District Court in Jackson.
2015. What is he asking?
He's asking if you've been convicted in the past.
Yes. Yes.
All right.
It was a long time ago, I guess.
It was last year.
Oh, that, okay.
Yeah, that one. Okay.
Yes. Sorry.
Yes, we would stipulate to this is the second judge, or this is she's pleading to a second, we'd stipulate to the October 24 conviction.
All right. Ma'am, you understand that if I accept your plea and you commit misconduct as defined in the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that any sentence evaluation the court would no longer be bound by, and you could not withdraw your plea. You understand that? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Judge.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be November 3rd, 2025, 9 a.m. before Judge Freshow.
Does the defendant remain on a scram tether at this time?
Yes, I still have.
If he's on a scram, he's going to stay there. Bond will continue.
Thank you, Judge.
Thank you.
Okay.
Court calls the case, People versus Vandalist Patterson.
Assistant Public Defender Davi Lieb on behalf of Mr. Patterson, who's approaching from my right. And Your Honor, I do have a plea form that I'll be having Mr. Patterson execute at the podium, as well as an advice of rights.
Well, what are we doing then? Why isn't it into the court before now?
Your Honor, I just received the form this morning and completed it with the prosecutor. Peter, I just received the offer yesterday as well.
Okay, let's go.
Thank you.
Really? Have you talked to him at all?
Yes, Your Honor. I did talk to him extensively yesterday. Just have not had a chance to have him complete the paperwork. This has all been reviewed with him, just simply not yet signed. I just need to sign your name there.
Court now has a plea form that indicates that the defendant is going to be pleading guilty to counts 5, 6, 7. All of attempted resisting and obstructing a police officer, 1-year offenses. Upon a successful plea to that, counts 1, 2, 3, and 4 will be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
May I have him sworn?
Right here. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Lance Patterson. Sir, it is this court's understanding that you're going to be pleading guilty to 3 counts of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court. You understand that, sir?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
To the charge of attempted resisting and obstructing as contained in count 5, how do you plead?
Guilty.
To that same charge as contained in count 6, how do you plead?
Guilty.
To that same charge as contained in count 7, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
You're on which one?
Probation.
Probation? Were you on probation at the time of this offense?
Yes, sir.
You understand that this could be considered a violation of your probation?
Yes, sir.
You understand that if it is considered a violation, you could be sentenced to the maximum allowable under those other charges in that other court?
Yes, sir.
Understanding that, do you still wish to plead guilty to this case?
Yes, sir.
Anybody promise you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of August 10th, 2022, at the location of 1411 DeSoto Avenue, Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with 3 officers or deputies of the Washington County Sheriff's Office?
Yes, sir.
What happened?
I resisted arrest, and we got to.
What?
I resisted arrest and.
They were trying to arrest you?
And I resisted, yeah.
How, in what way did you resist?
By not, letting them put the handcuffs on me, sir.
So they were trying to put handcuffs on you and you resisted in some fashion with your body by moving it or doing something along those lines to interfere with them doing that?
Yes, sir.
And you understand at that time, would you agree that they were performing their lawful duty?
Yes, sir.
Sir, if I do accept your plea in this case, your pleas in this case, you understand that if you commit misconduct between the time of this plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation in this case, and you could not withdraw your plea.
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor. Thank you.
The court will accept the defendant's pleas of guilty to counts 5, 6, and 7. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
November 6th at 10 a.m.
November 6, 2025, 10 a.m. before Judge Washington.
Thank you, Your Honor. I did want to address bond if possible.
Go ahead.
Your Honor, Mr. Patterson has now accepted responsibility for his actions by pleading guilty. He tells me he's completed the Dawn Farm and Jail program. We'd have no objection to a tether. He's very eager to get back to work and see his children. He's also been working.
Is he released on his is there a probation violation?
There's not a probation violation on this case. However, I would ask that you remain until sentencing and Judge Washington can address this. He was the one that failed to appear back in 2022. So at this point, a few times and I would ask that it remain as set to keep this sentencing completed.
I would just additionally note that he has some ongoing medical conditions that require follow-up and that he has been actively engaged in seeing medical providers at U of M, so he does have ties to the area in that respect.
Yeah, but he didn't come back and see us for 2 years. Plus. Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Omar Smith. This one, it is.
Go ahead, you go first. And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Omar Smith, who's appearing via Zoom from the Washtenaw County Juvenile Detention Center, as well as
Michael Vincent appearing on behalf of Omar Smith, Your Honor.
All right, Mr. Smith, can you state your name, please?
Omar Ernest Smith.
I have no volume.
You're muted, Mr. Smith. Can you
No,
ask
he's
Mr.
not
Hall to
muted.
unmute?
I have no volume. Try again, Mr. Smith.
Omar Ernest Smith.
Yeah. It's on their end.
Yeah.
Okay, they're gonna, can you tell them to log out and then log back in because I can't hear you, sir?
You just take a camera and all that.
You can't hear us? Nope. Probably best you log out and log back in, but if you want to work on it, we hear you. I'll pass the matter briefly. Court does call the case People versus Juliet Barnes.
Over water assistant prosecutor.